no reason has been advanced why the investigating officers would have done away with the shot which they collected from the accused house, find a different shot, subject it to forensic examination, and is found to have the deceased blood. It is my finding that this shot, which was taken to the garment analyst for forensic examination, is the same shot which Pamela, the house help, has identified, is the same shot which Jennings, who was at Roadhouse with the accused person, has identified, is the same shot Chelagat, who was with the accused on that day, has, is the same shot which is entered in the inventory. At this point, I want to go to the evidence adduced against the second accused person. I don't need to replay what the state and the prosecution said. I've already spoken to it. But I want to bring in the evidence of the second accused person and the submissions. It is her evidence and the submission is that I did not know the deceased. It is her evidence and the submission that I had no reason to kill her. In fact, she says in her submissions, if I knew, leave alone killing, that there was a plan to kill her, the conscience of my banks would not allow me to keep quiet. I would report. She says in her submissions, yes, my phone went off, but says, my phone going off is not commission of a crime. And it was not switched off because I was committing a murder. She says in her evidence and submissions, I gave the first accused persons the vehicle. Yes, it was my vehicle, but I have no control over it when he has it. She says in her evidence, no forensic, no data, no eyewitness places me at the deceased house on the material date. She says in her evidence, the people who visited the deceased were of male gender. I'm of a female gender. And no one has said there was a lady who visited the deceased on the material date. She says I've explained throughout, where I was throughout, from the time I reported to work, to the time I joined the interview of the former governor, to the time we went to Q launch, and then went to 40, to the time I went home. It was the duty of the prosecution to displace my alibi. They have not. And she says, if they're asking this court to convict me for aiding and abetting or an accessory after the fact, there's no evidence I did. And if there is any evidence of anything I did, it has nothing to do with the murder. It has something to do with the shooting incident. And tells and analyzes and crashes and says, the murder was on 19th, the shooting incident was on 20th. The murder was by a sharp object, the shooting was by a gun, excuse me. And so they are not related. I am not accessory after the fact. I will not read for you is an accessory after the fact. I will not read for you what the sections on aiding and abetting. You will read it for your own benefit when we come to copy of my judgment. As I read, I see a few errors, we will have them corrected. And so for her, the sum total of evidence adduced, either through oral or documented evidence, does not show that she was involved in the murder in any way. Oh, but she says again, I did not witness the burning of any cloth, and then goes on to say, if anything is the case anyway, the cloth were burnt in a public place, and the investigating officer did not establish whose place it was. Then finally says this, my relationship with the first accused person, and she says, then, my relationship with the first accused person then was that of cohabitation and aiding him to get treatment after he was shot. It's a constitutional right under Article 43. If anything is the case, you can't take a gunshot wound lightly. She says, by any stretch of imagination. She then crowns her submissions by coming to the doctrine of last seen and says, if there is anyone to be asked as to what happened to the deceased person, it's the people who are last seen with her, who are Waridi, Kaka, Owen, and the first accused. Let's look at the evidence. The defense by the second accused person is an alibi defense. The law is settled. One, it must be raised at the earliest, and two, it is the business of the prosecution to displace it. So when the accused person says, I woke up in the morning, I did 1, 2, 3, and removes themselves completely from the commission of the offense, it is the prosecution to say, no, you did, what you are saying is not true, you are. And let me tell you why that is the law. Please join me with the case of Kiare versus Republic in 1984. This is what the court said. An alibi raises a specific defense. And an accused person who puts an alibi as an answer to a charge does not in law thereby assume any burden of proving that answer, and is sufficient if an alibi introduces into the mind of a court doubt that is not unreasonable. All right? But it suffices to note that relying on an alibi defense, the entirety of the prosecution evidence must be considered, either direct or circumstantial, so that the court is appraised to establish whether that accused person was elsewhere and not at the scene of crime. Further, the conduct of the accused and the decision to raise an alibi during the defense hearing case, if that be the case, should not escape scrutiny of the court. Adedeji versus State, failure by the police to investigate and check liability of alibi would raise reasonable doubt in the mind of a tribunal and lead to the quashing of a conviction imposed. Ricky versus State, Free State High Court, the acceptance of the evidence on behalf of the state cannot by itself be sufficient for rejecting alibi evidence. Something more is required. You can read more on that. My last few pages will be dealing with the conclusion, but I want to take a tour, because at this point I posed a question: was the second accused person involved in the commission of this offense? I said, hold on. I have then moved to discuss an issue that has played in this matter and has been identified as distinct from the matter before the court, and that is the gun shooting incident. So let's move to the gun shooting incident. By an OB number 79 of 21st of September 2018, produced in this court as prosecution exhibit number 33, the first accused person reported at Langata police station that while he was going home, Royal Park Estate, he was shot by thugs in what was described as a robbery. Subsequent thereto, he wrote a statement to that effect with the police. Similarly, the second accused person on 28th of September 2018 wrote a statement in support of that report that the first accused person was shot by thugs while going home. 28th September, I've had the benefit of that statement. It's marked as prosecution exhibit number 109. I have read it in its entirety. It suffices to note this. On 29th, the following day, the second accused person writes yet another statement on the shooting incident and retracts what she has said in the statement of 28th of September 2019. This time her evidence and her statement is that no, he wasn't shot at the gate. It's an incident that took place in our house. Now, Brian Kasaine Spira, the owner of the gun, testifies that while asleep, the first accused person went to his house groaning in pain and said, "Oh, Brian, please rush to my house and secure the gun." Remember, the gun belongs to Brian. He's given it to the first accused person. The gun has fired or been fired or whatever. So Brian rushes to the first and second accused house and secures the gun. What does he say about his observation? He says, "I found blood on the floor, and that when the first accused person came to my house, he had blood all over the chest." Who else speaks to these events? The house help. She says that she had noise, and when she went to check, she found blood, she found a gun, and her concern was first of all to secure the child from that scene. But she says she saw blood. There is evidence of PW27, Eunice Mohammed, who was the caretaker at Royal Park Estate. He says, no, if there was a gunshot incident at the main gate, I would have known as a caretaker. There wasn't. Kasaini comes back. Remember, Kasaini was a neighbor to the accused persons, and he says, if there was a gun incident in our estate, ingewekwa kwa mtandao ya estate association WhatsApp group. It wasn't there. What does that say? It is the finding of this court that the report made to the police by the first accused person The statement made by the second accused person on 28th of September was false. The first accused person expressly admitted he lied in his evidence in this court, before this court. Now, what is informing this lie? It is very clear that Brian Kasaine had given the first accused his gun without authority. And so according to Brian, when he realized that his gun has been used, his first concern to the first accused person was, what are you going to do? And the words of Brian in his evidence is that the first accused person told him, do not worry, I'll take care of that. I will report it as a robbery. Now, let's look at the legal, natural, probable, and moral consequences of a lie. The case of Kinuthia versus Republic, 2003, the Court of Appeal had this to say. I will repeat. Kinuthia versus Republic, 2003, EKLR, the court had this to say. I quote, where the court doubts the integrity of a witness, then the court cannot accept the evidence of that witness. I will repeat. Where the court doubts the integrity of a witness, then the court cannot accept the evidence of that witness. The court went on to say, in a criminal case, a witness should not create an impression in the mind of the court that is not a straightforward witness. That if a witness raises suspicion about his trustworthiness or does something which indicates that he has doubtful integrity, he will be deemed to be unreliable, which makes it unsafe to accept his evidence. Please also look at these other cases. Kimani versus Republic, MTG versus Republic. My analysis of the evidence. In relation to this issue of giving false or denial, the first accused person says, I'd never met the deceased. Core data shows he met the deceased. The first accused person is alleged to have told witness number 7, Owen, I stay in Emali. Evidence reveals the contrary. The first accused person gives the reason why he's wearing a kanzu and says, I'm going to meet people in Isli, from Muslim community. He does not reach Isli. It turns out the kanzu was worn, left, went where he went, came back. And in fact, by the time he's going to meet the second accused person and the others in Westlands at midnight, he has also removed the kanzu. The first accused person asked Kasaine to give him a gun for training. The gun is found, evidently, at the time the offense is being committed, at the scene of the offense. And of course, his own confession, I lied about the gun shooting. The second accused person contradicts her own statement by the statement of 30th and says, 29th, now I'm clear in my mind. The statement I gave you yesterday was a lie. Statement of 28th was produced as exhibit 109. Statement of 29th was produced as exhibit number 10. Once it's produced in evidence as exhibit, I use it. Before I move to the very last tale of my judgment, allow me to address the issue of contradictions and the law. It is the first accused, and by extension, of course, the second accused again says, look at all these contradictions in the case of the prosecution and find that the prosecution have not proved their case beyond reasonable doubt. And 4 others versus Republic. The court says this: in certain criminal cases, particularly those which involve many witnesses, discrepancies are in many instances inevitable. I'll read again. In certain criminal cases, particularly those that involve many witnesses, discrepancies are in many instances inevitable. Philip Nzioka Watu versus Republic. Court of Appeal had this to say on contradictions. However, it must be remembered that when it comes to human recollection, not witnesses recall exactly the same thing to minutest detail. Some discrepancies must be expected because human recollection is not infallible, and no two people perceive the same phenomena exactly the same way. Joseph Maina Mwangi versus Republic. Lays the legal principle that the court will not disregard the evidence of a witness on the ground of contradictions unless the contradictions go to the root of the case and create doubt as to the guilty of an accused person. And the court had this to say on that: in any trial, there are bound to be discrepancies. An appellant court, in considering these discrepancies, must be guided by the wording of Section 382 of the Criminal Procedure Code. Where such discrepancies are such as to cause prejudice to the appellant, or if they are inconsequential to the conviction and sentence. What are these contradictions this court has been invited to look at? Contradiction on the time Aaron went to the house of the deceased. Contradiction on the cloth. Some people said he had a cancel, others didn't say he had a cancel. Contradiction, one witness said, I saw him with a bag, another one, I didn't see him with a bag. In my finding, and it is the finding of this court, the contradictions the defense has invited this court to look at are inconsequential. They do not go to the root of the matter, and the evidence of the witnesses cannot be disregarded on that ground. I am expected to be bringing the curtain down, but I'll go to the last ingredients, those of us who are working with me. And I have to pose a question and answer at this point. Then I'll come and answer that question. And I will repeat the question. Did the first and second accused person kill the deceased? I will answer it. But if, before I answer that question, let's look at the last element of malice aforethought. I'll look at 2 things, then I will close. I'm sure you're wondering what is the next thing she's going to look at, so let me whet your appetite. I'll look at malice aforethought, I'll look at circumstantial evidence, then I'll close. I'm sure the lawyers understand why this judgment had to be this long. There was no option out of it. Please join me in looking at Section 206 of the Penal Code. And just to save a bit of time, I will not read because I've captured it from the law. Please allow me not to read, I pass. But it talks about Malice aforethought shall be deemed to be established by evidence proving any of the following. Then it gives the circumstances. Please allow me not to read. But maybe I need to just point out subsection C, an intent to commit a felony. So you'll be deemed to have had malice aforethought if your intention was to commit a felony. Now, in the instant case, what the prosecution are arguing is that even before the day of the murder, the first accused person had already started preparing, premeditation. And so how do they support their submission to that effect? We go back where we were earlier. Look at his conduct before. Look at his conduct during. And look at his conduct after. So let's just do a recap. The first thing I have to belabor it, the first accused person stole the ID of Dominic Becerra Harui on 17th of September, 2 days before the murder. And why this court has arrived at the conclusion that he stole the ID is because of two things. One, he resides within the Royal Park estate where the ID was stolen. Is it a coincidence? Number two, the ID was never recovered. The owner had to get a duplicate. And number three, the witnesses to whom he presented that stolen ID have identified him on the ID parade as the person who presented the ID. So it's not hard to join the thread. And my finding is that the first accused person stole the ID of Dominic Becerra Harun 2 days before the commission of the offense. Secondly, the evidence analyzed reveals that this first accused person, other than the cloth he was wearing, he carried a bag, and the house help has testified that he had a bag. That evidence of the house help has been corroborated by the evidence of Jennings, whom he joined and who was his friend. And Jennings says, yes, he had a bag, and it's in that bag that he removed a counsel. So the question is, why didn't he wear a counsel right from the time he left home? Does the carrying of the counsel to be worn just before the murder and removed immediately to the murder part of the plan? Does it constitute malice aforethought? Number three, it is evident that he had borrowed a gun from Kasaini. He was supposed to return the gun after 2 days. He didn't. Then just before he went to the deceased house, he took the gun and went with it. Does the fact that he borrowed this gun even before the due date, or the material date, or the fateful night, part of his plan to commit the murder? The statement to Owen. In other countries, you can commit an offense and walk out with it. You can't walk out with it, but in Kenya, you can commit an offense and walk out with it. Because, and even impersonate, no one would really follow you. We don't have that. What does it speak to? Number five, the evidence of Jennings is that he was left waiting for the first accused person at a petrol station. Earlier on, when they're having drinks and food, they were discussing about setting up a security firm or company. He says that when the accused person, before the accused person left him waiting, he told him, I'm going to meet, he spoke about a girlfriend who was coming from South Sudan. And he says when the accused person came back, he told him that he had quarreled with a girlfriend from South Sudan. But even more so, that when he came back, he looked agitated, he was not in the mood, and seems to be in a hurry, and he didn't want to advance anymore the discussion they had. Republic versus Richard Itweka, Wahiti. Does the nature of the injuries that the deceased suffered speak to malice aforethought? That case, the court held that severity of the injuries is evident that they were inflicted by a person who had no any other intention than to cause grievous harm and kill. Let's look at the injuries the deceased suffered. I'll take you to the doctor's evidence. I picked this from the post-mortem report, that the deceased airwave had been shot through and through. And the right carotid and the jugular veins had been severed. That is cut through and through. Now this brings me to what played before this court heavily as I had this case. On very many occasions and during cross-examination, the counsel for the first accused person kept on putting to the witnesses, have you ever slaughtered a goat? And the witnesses would say, yes. And what impression was created in the court's mind? That the manner in which the deceased was killed was akin to slaughtering a goat. And so the argument of the first defendants accused was that if I really killed her the way she was killed, the way a goat is killed, how come the blood didn't go on my cloth? I have had the benefit of looking at the photographs by the scene of crime, and it's very clear that the deceased and the person who killed the deceased did not intend to give her room even for 1 minute to survive. Now, I've said Dr. Njenga said that the airwaves and the jugular veins were cut through and through. So I checked on the functionalities of these organs that were targeted. And this is what I found. The carotid arteries are major blood vessels that provide one's brain, supply blood to the brain. I established that a person has 2 of them on either side of the neck. I discovered that they're actually a cause of at least 1/3 of all strokes. And that a stroke occurs when something blocks blood flow to your brain and causes brain injury. Therefore, they are a very important part of one's circulatory system that sends oxygen-rich blood to organs and tissue in the head and in the neck, including the brain. And then checked on the veins that were targeted. And I discovered from my search and reading, they are major blood vessels that stretch from the upper head, from the head to the upper chest. There are 3 pairs, total of 6. And the reading, my further reading shows that when the arteries and the veins that were injured on the deceased body are severed or they're cut, then no blood is supplied, and the victim cannot even survive for a minute. is my considered observation, opinion, and finding. And it's noteworthy that this deceased person had injury on the neck only, occasioned by a sharp object. It is my considered opinion the target of the neck clearly indicates that the perpetrator was fully aware, intended to, and did actually target for purposes of instant death of the deceased person. Does this connotes malice aforethought? I did, and I've made an observation. When you look at those photographs, you don't want to look at them again. The slitting of the neck was not just on the front, right up to the back. And I made an observation, it's no wonder, and then in our hearing we heard of slaughtering of a cow or a goat. The evidence of Chief Inspector Otieno is that the person who committed this offense was not an amateur. He's not a person who has no training in military, or because the way it was done with such precision that you can't go wrong. And so I asked myself, does the first and or the second accused person have any training in military or military training? And that took me to the following. According to the evidence of the prosecution witnesses, and I'll start with the evidence of Jennings, when he met the first accused person, they were on a VIP protection exercise, and it said that that is when the US president was in Kenya. And he says they then became friends, and they were actually discussing how to form a security company. The house help says in her evidence, she asked the second accused person what the first accused person was doing, and the second accused person told her he's a soldier in Dubai. Owen says the deceased introduced the first accused person as a security in Interpol and Office of the President. In fact, according to Owen, they even spoke how he was going to help this witness secure a firearm. Jennings says that the first accused person told him that he had been working with a security company in Dubai. And he also told him that he was offering VIP protection to state officials in Kenya while on leave. According to Kasaini, he gave the first accused person a gun because he knew the first accused person was working as a private military officer who covered several politicians under an undercover, so to speak. That he worked as a private military contractor in Dubai and was guarding the former Senator Joyce Ray. It is the finding of this court that for one to engage in VIP training, they definitely must, protection, they definitely must go through training. And that training would not be too far away from the training offered to a military officer. And if the first accused person went through this and he murdered the deceased, then he had the know-how. The conduct of the first accused person and his conversation with the deceased brother. When the deceased brother told him, look, can you help me get press? Can you ask your fiancé who is in the media industry? It is in evidence. The first accused person told me, forget about the media, they won't help you. I don't know, you are here. I have a private company, let me do it for you. What does that statement speak to? A further issue I picked up, he says, look, the person whom the deceased allowed into her house was Dominic Bisera Harun. And she must have known somebody by that name, and that's not me. And my simple finding on this is this. If this first accused person is introducing himself, I work at State House, I protect the President of the States of America, I am in a security company, I am an undercover, is it far-fetched to imagine that even when he told the guards at Ramuria Gardens, I am Harun, the deceased would not have contradicted that, because the deceased also introduced him as somebody who works at State House. So we all know that their true identity. And that could inform why, even when he said, I'm Harun, and the deceased, knowing whom he has said he is, would quickly say, let Harun come in. And then in the house gives him his true identity to the other persons in the house as well. So I didn't find it difficult in coming to a conclusion that it is explainable. Is this case based purely on circumstantial evidence? And has the prosecution met the threshold of circumstantial evidence? You'll allow me to just pick extracts from the cases. I'm coming to the tail end of my judgment. Cases that speak to circumstantial evidence. Some very critical areas, I think, will guide my findings. Ahmed, Mohammed, and another versus Republic 2019 speaks to circumstantial evidence is often the best evidence. It is evidence of surrounding circumstances which, by intensified examination, is capable of proving a proposition with the accuracy of mathematics. It is no derogation from evidence to say that it's circumstantial. Republic versus Juma Kaviha Kalama. Circumstantial evidence is particularly powerful when it proves a variety of different facts, all of which point to the same conclusion. I have given emphasis, my own emphasis, on the following. It works by culminatively in geometrical progression against other possibilities that has been likened to a rope composed of several cords. One strand of a cord might be insufficient to sustain the weight, but 3 strands put together may be quite of sufficient strength. There may be a combination of circumstances, no one of which would raise a reasonable suspicion, but the 3 taken together may create a strong conclusion of guilt with as much certainty as human affairs can require or admit. Emphasis added. Having considered the evidence in this matter, It is the finding of this court, yes. The case is based on circumstantial evidence, but the prosecution has adduced adequate evidence and has met the threshold. And to sum up, did the first accused person kill the deceased? It is the finding of this court. I'll play back for purposes of my finding. The first accused person stole the ID of Dominic Becerra 2 days prior to the commission of the offense, armed himself with a gun, carried a counsel, put it over his cloth, went to Ramuria Gardens, disguised his identity, gained access to the apartment of the deceased, murdered the deceased, left the deceased house, changed his clothes, and eventually went home and burnt the cloth which he wore during the commission of the offense. It is the finding of this court that all this evidence taken culminatively leads to a strong conclusion that the first accused person murdered the deceased. And therefore, it is the finding of this court that the prosecution has proved beyond reasonable doubt all the ingredients of the offense of murder. The death occurred, the cause of that death, the person who, and in this case the first accused, I'm still on the first accused person, committed that offense, it was not a case of homicide, excusable homicide, it was unlawful. And therefore I find the first accused person guilty as charged herein of the offense of murder, that on the night of 19th of September 2018, at an unknown time at Ramuria Gardens apartment, Kitara Lane off Dennis Pritch, with others known before this court, he murdered Monica Nyawira Kimani. The evidence by the prosecution against the second accused person did not place the second accused person in the house of the deceased on the material night. There was no evidence that she had ever communicated with the deceased. The evidence that the prosecution have brought before this court on the second accused person relates to the events of 20th of September 2018, and that is the shooting incident. And in that regard, having considered the provisions of Section 129 of the Penal Code of Kenya, and the second accused person having had no objection to her two statements which she gave the police, one saying that the second accused person, the first accused, was shot in the house, and then retracting that statement the following day, only leads this court to the provisions of Section 129 of the Penal Code, which states as follows. That Section 128 creates an offense, which is an offense of giving information, false information, to a person employed in public service, and states as follows. Whoever gives to any person employed in public service any information which he knows or believes to be false, intending thereby to cause, or knowing it to be likely that it will be that he will thereby cause the person employed in public service A to do or omit to do something which the person employed in public service ought not to do or omit if true state of facts respecting which such information is given were known to him, or 2, to use lawful power of the person employed in public service to the injury or annoyance of another, is guilty of a misdemeanor and liable to imprisonment for 3 years. The statement which the second accused person gave to the police on 28th was false. The statement of public service. The statement intended that that person investigates that offense. That statement was retracted by the second accused person the following day by a different statement now speaking to what is said to be the truth. There is no timelines in criminal law when you can prefer charge against a suspect. The Limitation of Actions Act does not apply to criminal offenses. It is my considered view that the charge brought against the second accused person was not the proper charge. Section 157. So 157 gives the power to institute and prosecute a person suspected of committing the offense, Office of the Director of Public Prosecution. And the question posed at this stage is, was there an offense committed when the second accused person gave a statement to the investigating officers at Langata Police Station, which turned out to be not true? I say no more. The Office of the Director of Public Prosecution know their mandate. The result is that the prosecution did not adduce adequate evidence for this court to find the second accused person guilty of the offense of murder of Monica Kimani on the night of 19th of September 2018. The first accused person is convicted on the charge. The second accused person is acquitted of the offense. That is the end of the judgment. We'll move to the next stage. The state you are supposed to go next.
You're the first one.
So I am expecting the records. Ibene?
You'll be asking for those things. To present the CRO report, which is the previous records for the first accused person which has been convicted. In the meantime, we'll also be asking for a pre-sentence report in relation to the first accused. And we'll also be praying that the first accused be remanded at Nairobi remand as we await to get the previous conviction and also the sentence report. We'll also be praying for type copy of today's judgment.
Okay. May I know whether Professor Nando, you have anything to say? No. The victim's family, Musembi, sorry. Professor Nando, yes. Okay. Professor Nando, for the first accused person, you have something you want to tell the court?
Your Honor, first of all, we appreciate the system that this kind of report this conclusion. We do pray that we be given time also for us to prepare our mitigation in favor of this person. We also seek the indictment of this one of the court that it maintains the bail terms that were granted to the first accused person who have convict. Please note of that, please. We are very concerned when the mitigation, when required by this one of court. We also pray that the exhibits that were and other items that were taken this person under the personal nation, even the case was included, and Kimani specifically on performance. That's
Okay.
My deputy, in the last session we didn't take directions on dressing, so I'm afraid that you excuse me now on dressing that.
That's okay.
Thank you. The second thing, which is very important, is to thank you, my lady, for the attention to detail. You clearly gave attention to all the details, both factual, legal, and the issues in between, and we really want you to know that we appreciate as defense your attention to detail. Lady, for the second accused, we want to say, and we wouldn't want to take any for granted, sorry for the first accused. We are grateful for the acquittal on the charge that she was facing, and we pray, my lady, for the release of the securities that have been put in to study in Masaka.
Are you asking for the release of security?
Yes, we pray. Yes.
That is. Well, you realize when this matter was going through that process, I wasn't hearing the matter. So what is it that was deposited in court? I think it's administrative.
Yes.
And for me, it should actually just be a natural process, administrative, unless, of course, the state, as I'll be indicating, have a right to appeal.
But they do not intend to appeal.
I do not know where you get that from. I don't know. That I'll leave to you.
Yes,
But of course, if they are not, after 14 days, you can seek for release.
okay.
We need to give them the 14 days. Okay?
Maybe that's on behalf of the second accused, and thank you very much.
Okay, so of this nature, you cannot afford to pronounce a sentence without, of course, a Maribe report, because it is that report that will take into account the views of the victim's family. And so we will start over this matter to another date when we'll be dealing with the sentence. It will also allow the prosecution an opportunity to seek for CRO those records, so that the court is guided whether this is the first offense that the first accused person has been found guilty of and convicted of, and it will also allow the first accused person an opportunity to prepare mitigation. And then now need to take a date. We also allow the court assistant we take a date for dealing with the sentence. Diary. It's not my diary. Now, as I had indicated earlier, I'm starting my leave on Monday. I think Professor Nando, you are aware of that because there are other matters that you have before me. Just to guide you, I'll be away from the 12th of February to court assistant. You don't have a diary where I can just quickly pick 24 February to 11th of March. You'll be before me on 12th. On 11th. Okay, so you want us to give you the 12th of March?
Yes,
You have two other matters that are coming for judgment before on 8th of March?
yes.
8th of March.
8th of March. Can you get it from the same day?
Okay.
You are also coming here.
Am I coming here?
Yes, 8th of March.
Yeah, it's a Friday. I come here on a Friday. Okay, 8th of March. Yeah, okay. I thought we were dealing with those matters virtually, Prof. You want me to come here? Okay. That's okay. I can. Okay. May I have the first accused person stand up? You will appear before the court on 8th of March for sentencing. Unfortunately, after conviction, I'm unable to accede and or allow the prayer by your counsel for you to remain on bond. I'm cancelling your bond. You'll be held in custody on the 8th of March. Okay? So that is done. Court assistant. Put in the file. You know, there's another file with so, as I adjourn court, may I take this opportunity once again to sincerely thank the first accused person. Please sit down. The councils who have been involved in this matter. We've had dedication. I don't remember how many times this matter was ever adjourned because the councils were not there. I do not remember how many times, probably the last time the matter was coming for judgment when the accused persons were not there. The state was always in attendance, and we've only been able to deliver this judgment because of that support that I got from the councils on both sides. I want to thank you sincerely for that support you gave the court, and of course the commitment. There are things that I will not want to speak to, but which of course we all know. But a general statement is always good to respect the court and just give the court its due respect. We don't sit in this court as in our personal capacity. I believe what I see behind here speaks to the authority of the court. And in most times, the court will not have an opportunity to respond to certain communications. The last bit of it would be me. And throughout this matter, I knew clearly what my purpose was to deliver judgment and not to get myself into response to social media or otherwise. And that has nothing to do with my decision. It has everything to do with a plea on my own behalf and on behalf of my colleagues and the entire judiciary. Let's support the judiciary. When a matter is still in court, it's just good to allow that matter to be dealt with. Any comments that would probably be adverse are not necessary. Please, Kenyans, support the courts. I'll leave it at that, okay? Otherwise, Press, asanteni sana kwa kuja. When I called the parties to come before me on Wednesday and said, are you ready for this judgment? I knew the press had left knowing we are coming on 15th of March. Hope I didn't surprise you. But from the population I'm seeing here, I think information reached you in time. And as I had said, please, for those who may not be able to come to court, make it online. And I had been assured that we'll have an online, but nothing lost. The most important people who needed to be present are in court. So asanteni sana kwa kuja. And finally, thank you for being patient with the court. My judgment is about 117 pages, and it may not take one day to write. Okay? If you want to know my workload, please visit Naivasha. You will understand. So for me to come up with this judgment, I don't want to praise myself, but sometimes it calls for quite a bit of work going into it. So I'll just say that thank you for being patient with the court, and I do appreciate the indulgence. Thank you. Yes, Professor, you want to say something?
Yes, my lady, I wish to retaliate our gratitude efforts that you have wasted and the attention that you have given. Always given it priority. We also respect your decision. We may not agree with you, but when we do not agree with you, the law provides for what to do.
Sure.
Therefore, rest assured that we respect you, we respect your decision, we shall live with it, and we shall act and do what the law provides for.
Yeah.
Appreciate your efforts, you have done your part, and this so that on behalf of the prosecuting person, we really appreciate. I remember you allowed adjournment more than 2 years of course of you. We really appreciate that. On behalf of the pastor, the convict and also the family, we appreciate and thank you.
Karibu. Yes.
I expected my senior to do this immediately. I just wanted to say, on behalf of all the accused persons permitted, we apologize for any excesses that may have emerged in the social media. In the same way you said you thanked the gallery for being patient, we want to thank you for your patience when needed. And lastly, we saw you turn your back and look at the sheet. And we thought that was canon. Thank you very much, my lady. We want to say we are grateful and we apologize for any excesses.
Thank you.
My lady, equally for the execution, in fact I should have started by thanking the court for the patience and also for expediting this matter, because it's been a very long journey. We've handled it before different judges, but at this point we came about 2 years ago. We picked it out and you have managed to conclude it and hard work that you have put in.
Lady, on behalf of the family of the victim, we are most grateful to the court for the diligent work that went into the judgment, the analysis. We thank you for bearing with us sometimes, bearing with counsel, with the media, even when we may have not this court. So thank you so much.
I want to assure you this court is extremely at peace, and this court takes offense on nothing. Okay, so with that, kindly may I request the court assistant, we now officially adjourn the court. Have a good afternoon.
Ndio ya maana. Atajichukulia. Nawekea tu hapa. Cheki. Naomba nataka kupiga hivyo. Senior. Just give us a few minutes.